So, Del, could we get some comments from you in general about the cannabis laws that are being proposed in different First Nations by Chief and Council? The Henvey Inlet proposed cannabis law has a prohibition on cannabis and sets out certain rules and fees that have to be paid and a whole set of systems. And I'm just wondering if you could speak to the issue of jurisdiction and the Constitution and as it relates to these matters.
Yeah, I've read through it. My initial comment, which I'll follow up with the reasons, is this is a bunch of legal garbage. I don't know who could have written something like this without taking into consideration Section 3525, your Aboriginal and treaty rights. Now, that obviously the Chief and Council's kind of bought into this thing, but their biggest problem is that they are Indian Act Chiefs and Councils. They were set up by John A. MacDonald, and they are primarily responsible to the minister. All of their reports have to go to the minister. They are really not responsible to the people. And as such, they have a huge conflict of interest if they deal with lands and rights. And I would say John A. MacDonald done a number on them. It's not their fault, but they have no authority to do any of this stuff anyway because it clashes with their Aboriginal and treaty rights. And as such, I don't know where they get their information to do this stuff, but
Can you
Section 35 provides for a much better way of developing your economy. This is just totally restrictive. You can't do any of that stuff. It would cost thousands and thousands of dollars to try to monitor and enforce what they're proposing. And all it is your cannabis situation, which is going on all across the country anyway. A lot of reserves have 20, 30 shops and a few hundred people working now. And the economy in much better shape than, say, an economy in, I get north of Barrie, and all I see is just total poverty, almost total ghettoization with no economy. And the person responsible for this since they introduced the Canada's apartheid law, the Racist Indian Act in 1876, is the minister. He was supposed to have the economy all done. He's got all the authority. Your Chief and Council has zero authority except for beekeeping and noxious weeds. They can do a few things under their the other Indian Act they're trying to put them under is this governance nonsense. But they're putting a cart before the horse, because a big problem that people are going to face is that the Chief and Council, when they bought into this governance nonsense, they also agreed they would tax everybody. You have no economy here. You got no jobs or anything. How are you going to tax anybody? But for the people, that's what's coming. And maybe the Chief and Council hasn't told you yet. They got to tax you because they agreed to with their boss, the minister.
Can you explain how it is that you see cannabis as an Aboriginal and treaty right?
Well, it's a medicine, and my elders smoked it and used it and grew it, and it's always been a medicine with our people. So yeah, and why try to introduce all of these restrictions? We can't operate like the Caucasians do that occupy our lands because they control all the funding and the financing, and you've got us boxed in with your racist laws, and especially the Indian Act, and with all of its nonsense. It's blood quantum stuff. It's Jim Crow laws. It includes the Jim Crow laws. It is nonsense, and it should be quickly overturned with Section 35 and 25.
Is it is economic development and the ability to grow a plant on your land and to harvest it and to process it and to sell it, is that an Aboriginal right on an economic standpoint?
We're nations. Yeah, our nations would decide that. Not the Indian Act, John A. Macdonald club they call the Chief and Council. It shouldn't be called Chief and Council. That's an insult to our traditional chiefs and councils.
Mm-hmm. Del, what do you say to the legal argument that some Canadian lawyers and judges make that an Aboriginal right is only defined, in a set of ways that the Canadian courts have defined it as? Can you talk about what an Aboriginal right was meant when you helped to negotiate to put it in the Constitution?
Yeah. Section 35, 25, all of the other two sections as well, got into the Constitution because I opened an office in England. And in order for me to close it, they were forced to accept those things and what we meant by Aboriginal and treaty rights. And they were well informed at these committee hearings as to what Aboriginal and treaty rights were. But on the other hand, we are the only ones that can define that. Our rights are there for thousands of years. And any European Caucasoidic type of opinion that comes from and the legal thing has no force and effect on our rights, which were there for thousands of years. And they've been your Supreme Court. Well, we call them the grand poobah of their legal system. Has been giving nothing but partial racial interpretations, and that's all wrong. Our rights, if they are to come up before a court, should come before a independent court, away from the racist Canadian government and their provincial governments. Both governments we have no representation in anyway, and all we've been receiving from them is nothing but racism. And well, hey, I spent 5 years in a residential school under the most cruel, inhumane treatment that anybody could ever endure. I was lucky to survive. They used me as a biological weapon. They put me in with TB to infect the other kids. I was lucky to survive that ordeal. But sexual abuse was rampant in there, and the kids had no place to go. And most of them, hell, they were dead by the time they're 30. Just drank themselves to death. But that's my relationship with the church and the federal government.
So one of the things in this cannabis law is that it claims that Henvey Inlet is drawing its jurisdiction and its authority, rather, according to Section 7 of the Henvey Inlet First Nation Land Code. And it references the Framework Agreement on the Management of First Nation Land and subsection 20.3 of the First Nations Land Management Act. And that this gives it the authority to enact laws regarding the development, conservation, protection, management, use, and possession of Henvey Inlet First Nation land interests and produce licenses, and that it also lets them create offenses punishable on summary conviction and to provide for the imposition of fines, imprisonment, restitution, community service, and any other means for achieving compliance with such land laws. Can you break that down for us?
Yeah. Well, the initial problem with that is they are John A. Macdonald chiefs and councils, and they are responsible to the minister. They can't enforce any of this stuff, and they can't say it applies to to their people, because that violates Section 35 and 25, their Aboriginal and treaty rights as nations. And they're really trying to insert a racist position on this First Nation that, hey, nobody can implement such nonsense as that, and it is a bunch of racial nonsense. I don't know what kind of lawyer would prepare garbage like this, but it is garbage.
For me, I view the creation of the land codes that's enabling all this as a situation of take your eyes off the prize, and the prize being unceded land. And so with these land codes, it's enabled these organizations to uneffectually to cover up unceded territory. And so that seems to be a consistent agenda that's occurring here. And so the situation of nationality and nationhood is being usurped. And so the usurpation is constituting some very concerning illegalities that the rights of the people are being affected to where it's detrimental to their futures. And so it needs to be addressed. It needs to be dealt with. There's a very small group of people that are understanding this in any substantial way that at this moment. And I think, doing exercises like this video can bring about helping people understand that there's a bigger picture to what's being done here. So covering up for me is the beginnings of the establishment of criminal intent. And so what's all the cover up for? People, there's certain contingencies of people that don't view these things as cover up. They're writing it off as progress. And when you understand any part of the history, you establish yourself in the present, and you become cognizant of the reality of today's situation. You can then look into the future and you see a bleak storyline that's possible, and it becomes very motivating.
So we're seeing a lot of cases with these land codes, also with the creation of constitutions for these First Nations, and then a push into regulating things like cannabis, or setting up economic development corporations to run things. The argument that the people running these systems say is that these things, they may not be perfect, but they are advancing things beyond what was possible before, and that it's a good step forward that gives people more of a say, or more power, or more authority. Do you believe that, or do you see this as part of a step towards municipalization and integration with Canada?
For me, I see a bias. And so that bias system is instituting these agendas that are detracting from the original title holders. And so rather than embracing them and enhancing that situation, they choose to eliminate it. So the bias is it's always been there right from day one, and it serves little purpose in the way of coexistence. And so it's domination, it's apartheid, it's genocide, it's all these things that people don't like to think about or to talk about, but nonetheless they're still present, they're still being executed. And anybody that has any insight into the realities of the native folks of these regions are quite understandable and quite feeling the effects, so.
The basis for trying to promote such racist scribblings as that proposal there on cannabis is it's crazy. But I think all of Canada has to realize that the racism that we face has all been based on this debunked notion of doctrine of discovery, and unfortunately, that seems to be really permeate the minds of the European Caucasoid people that occupy our country and run both the federal and provincial governments. And as I said before, we have no representation in either of those places. So, in the end, we usually end up receiving the downside of anything. We receive their racism, and they've confined us in these concentration camps. Well, now ghettos, without no economy. But if you want to compare two situations, look at where they actually have put up a provincial style cannabis shop on reserves. What do they get? 2 or 3 people working. But in other places where they've gone traditional, you've got sometimes 20 or 30 shops and then employing hundreds of people. And that's the difference that it makes in the economy. So their implementation of that is meaningless. The people won't benefit from that at all.
One of the things of this law, like many other of the Band Council laws, is that it starts with establishing prohibitions. So these are prohibitions in relation to the possession, use, cultivation, propagation, harvesting, processing, manufacturing, preparing, packaging, sale, and distribution of cannabis within Henvey Inlet First Nation lands. So how would a Sir John A. Macdonald Band Council have the right to prohibit people from a medicine or from an economy?
The whole history.
None.
Okay.
The whole history of the Band Council, and I took a look into it, started to try to wrap my mind around this problem we're having. And so I dug up the foundation of the Band Council. I find it in 1884. And so with that came through the instigations of John A. Macdonald and a fella by the name of Edward Blake. Blake was the author of the Ontario Lands case, aka St. Catharines Milling and Lumber, which threw Indians under the bus using United States Supreme Court decisions, which was offensive to the laws of England and the rules of evidence of England. So we have issues with that. But in the formation of the Band Council under John A. Macdonald's regime, and his idea for it was to retain the ranks of the hereditary chief system, but make them lose their power. The Band Council, as it sits today, was formed as an experiment. And, many of us are of the opinion that it's quite a failed experiment. Everything that it's incorporated into it is set up to fail. And so I have major concerns for some of these large infrastructure projects that these bands take on if they're set up to fail. And the brunt of the victimization are the Native people that they're utilizing in exploitation to make those systems happen. So there's some real major concern. Inside the creation of the Band Council in 1884, there was some concerning things that I saw there. One was that the Band Council, or the John A. Macdonald's group, didn't understand the position of the Native power of women within the society here. So there were other concerning things. One was that they exempted the people from Oka, from the situation of the Band Council system, and that's still existing to this day. We can see it being reflected in things that are like the negotiation of the Algonquin land claim and the formation of a modern day treaty. We can see it here in the Band Councils along the coastline here, in how, if you do the examination of the treaty they say they exist within, and find the discrepancies that make a lot of frauds. And so we're having all this jurisdiction and authority usurped and misplaced via fraud, and it's very, very, very concerning for the future. And so we're asked to depend upon this for existence, and it's unacceptable.
Okay, in section in part 3 of the Henvey Inlet cannabis law, it says no person may carry on a cannabis business on Henvey Inlet First Nation lands unless A, the person is authorized to carry on that cannabis business under the laws of both Canada and Ontario, including the laws that would apply to the applicant or the cannabis business if located outside reserve lands in Ontario, and B, the person has applied for and received a valid and in-force cannabis land use permit issued by Henvey Inlet First Nation pursuant to this land law. So my question is, given what happened in Shawniga yesterday, where there was a provincial sheriff coming to enforce a provincial eviction on unceded, unsurrendered Indigenous land, is this section of the law that is bringing in the laws of Canada and Ontario, it's bringing them into the reserve and into an area that is under the Rowan Proclamation, and I'm wondering if you could react to that section specifically there.
When you lay the Robinson Treaty and the Rowan Proclamation side by side and you examine the two documents, you find some major geographical discrepancies. And so what these land codes with these band councils are claiming is unsubstantiated, because those issues have never been firstly spoke about in any public way.
We have no jurisdiction or authority to implement any of these things. And like I said, it's a clear violation of Aboriginal and treaty rights and their nation rights. They are a nation. And the province should be thrown out completely. They're just an administrative unit of the federal government. They're not a nation. And I don't know how they even got to include outside boundaries over your treaty lands here. They never talked to you about it. There's a lot of issues out there that have to be resolved, and the basis of those issues are really caused by the Caucasoidic racism, and most of that racism we get from the Caucasoid European colonials that have come over here and are promoting this ludicrous doctrine of discovery. A lot of them seem to be totally brainwashed with it, and we've got to get beyond the racism. So the government of Canada at some point has got to address this and eliminate racism from all of its laws and policies, and eliminate racism from all the upper program or the big manager levels, right from deputy minister on down. You've got to limit the racism. I don't know if that can happen. Probably not. But in any event, I think it's even more important. Our people got to finally stand up and fight this Caucasoid racism that I've encountered all my life, and of course I'm dedicating my next 10 years to fighting it, and I'm going to fight them all the way.
What is your thoughts on the Rowan Proclamation?
The Rowan Proclamation is valid because it is in the same category as the Royal Proclamation and the 1784 Six Nations proclamation that set up theirs.
The Haldeman Proclamation?
Yeah, the Haldeman Proclamation, and there's no provision in there to change any of that. These are proclamations that sit on their own. So if they don't have any mechanism to change it.
I want to get some reactions to Section 4 of the law, which references an application fee prescribed in Schedule A, and that is a $20,000 application fee if you want to start a retail shop, and a $50,000 application fee if you want to start a production of cannabis. Mm-hmm. Both of those fees are non-refundable, and then you have to pay a renewal fee of $5,000 a year. It's totally up to them, and I'm just wondering if you can react to this idea that you would have to spend all this money to be able to participate in the cannabis industry.
For me, when I examined the band council structure, I quickly realized that if you pay them enough money, they'll turn their head to anything. So that's what we're getting here is pay us and we'll turn our heads.
It's an absolute violation of Section 35 and 25. They don't have the right to do that.
Okay. They similarly say that on Section 4.02L, that there must be a mechanism to provide Henvey Inlet First Nation officials and federal and provincial enforcement officials with a right of entry and inspection without notice of your cannabis operation. So they're not really turning their head, even though you pay them the money.
Yeah. So what I was getting at was in the bigger picture of all of this.
They want outside racial control. That's what they want.
Okay, the next issue is in Part 5. It says that council shall review and decide all applications and motions to suspend, revoke, or reinstate a cannabis land use permit in camera. And then they go on through sections A to D to talk about essentially how they control information and don't, everything is confidential. There's an open session to record the decision, but the grounds of the decision are not, are not public, and the, who said what or how the decision was arrived at. Is there a problem with the secrecy and the
I would say that Henvey Inlet First Nation needs to first, before it goes waiving jurisdiction and authority, that it needs to have an assessment of its abilities, its properties, and its rights. And it's going to find that it's going to be disappointed with what it finds. So, creating more cover-ups is not going to remedy the situation. And so that's all you're witnessing in that document is just more and more layers of cover-up written into it. And so it's never going to remedy the actual problem that sits there in the fact that jurisdiction and authority is usurped. And so the continuation of that, so and I'm of the opinion that anybody that wants to subscribe to that is welcome to, but the disappointment of the reality of subscribing to it is going to be your problem.
Yeah. And the council now has to impose taxes on all the members of this First Nation. They are obligated because they accepted the feds' money.
So to do an inventory of the assets of the Henvey Inlet First Nation, you'll be surprised at what you find. You're going to find it's describing a whole lot of things that it really doesn't have the abilities or the rights to do. And so so the jurisdictions and the authorities that they propose, actually not almost, they are holding criminal intent. There's a whole lot. So people look at me and they think I'm a little crazy when I say that you're complicit in the crime of genocide. Mm-hmm. And when you subscribe to these usurpations and these cover-ups and these frauds, that's what you're dealing with. Is you're dealing with complacency in genocide. And given the current atmosphere, a lot of people might be able to relate to this now, because also not that long ago the word genocide was very taboo. It was not spoken, it was not heard, it was not a lot of things, and it is front and center in the current reality of Canada, the current reality of the native existence. It's front and center, and if you can't participate and look at some of these situations and recognize that, then you have no business. You have no place with dealing with the livelihood, the well-being and the welfare of these people, holding those as normalizations or as good governance practices, and you just can't make it out.
To conclude this, what is the way forward in terms of those people that are opposed to this draft law, who don't want to give up their sovereignty, who don't want to participate in a system of provincial laws on their territory? How do you go forward when the band council is trying to force this on people? Del, do you have some thoughts on that?
Yeah. I think they've well, the craziest thing about this is this being imposed without people realizing all of the negative aspects of this, and essentially, again, turning over control to the people that have been most racist to this First Nation and all First Nations. And the racism isn't going to get better. That's total racial control. And I would say genocidal. It has aspects of being genocidal. And they're going to have to start over totally.
Stacy, do you have any concluding thoughts?
When what I was going to relate earlier, which I'm going to do now. So in the creation of the Band Council, it was created by an act of the government, and it's called an Act for Conferring Certain Privileges on the More Advanced Bands of the Indians of Canada, with the purpose of training them for the exercise of municipal power. So, AKA puppets. And so there's only one way to speak to a puppet. And so you can imagine. So puppets have no position in the realities of the Anishinaabe people, specifically, which I refer to, and other peoples out there that are in a similar situation. Puppetry is tactic of usurpation. So we can look at the history of the Jew, and so we can find within the Nazi regime that created forming a Holocaust against these people, that they formed puppet governments in order to deny the Holocaust. And that's exactly, where do you think Hitler got the big idea from? He got it from North America and what was done
from Canada.
Yeah. And so, you know, the denial of the realities of the rights of these people has never been properly explained. It's never been properly documented, and has never been presented legally in any substantial way that promotes the freedom of these people. You know, we can go into the international governments right now. We can look at, something that we just been exposed to here is that there was royal assent given to the United Nations Declaration on the Rights of Indigenous People to be implemented into the foundations of Canadians' law system, which is the unamended 82 Constitution of the Charter of Rights and Freedoms. And so in the very open-ended Constitution that we find ourselves dealing with, you know, and so Dell is worked a huge majority of his lifetime to describe that and to bring substance to it and give it proper structure, you know. And so we get to be sitting here knowing that the Supreme Courts of Canada have taken Section 35, and Dell here is of describing the intention of Section 35, and us here sitting here today, we're dealing with the jurisprudence of Section 35, which are two very distinct situations. And so when Canada's Supreme Courts took it upon themselves to define Section 35 and create it into this, what they're calling the Pandora box of treasures, you know, it's been described that way, that, you know, we're now trying to basically deal with it, you know. And so, you know, the intention is always going to be there, you know, of what what these things entailed. And so how we're going to affect this, well, it's going to take firstly a very concise piece of knowledge that needs to be made universally known, become common within the idea of everybody that encounters it or wants to deal with it, you know. So for us, I think as people here, Canadians and Native people alike, are constrained by the open-ended Constitution, and so its amendment is very critical. It was there were stipulations when the '82 Constitution was made that it was to have meaningful amendment within 15 years. That was 38 years ago. And so none of these, the constitutional conferences of the 1980s and into the early 90s failed because the Canadian administrators failed to recognize what the intention actually was, and they all they had their sights set on was to form the jurisprudence that was in their favor. And you know, we're stuck dealing with it.
Bill, do you have any final words?
Well, there is so many agenda items, so many racial agenda items that have to be resolved. And Canada needs to eliminate racism out of its various laws. Province of Ontario as well. Well, we're in the province, but I think all of the provinces. And we've got to address racism. And I think our people finally have to stand up and fight back against this Caucasoid racism. And it's the European Caucasoids that brought all this racism to us through their doctrine of discovery. And they put it into the laws. They put it into their 1888 St. Catherine's Milling case, which was supposed to give them, okay, now they've got legal rights to steal our lands and resources. And that's all they use it for.
Yeah, so the condition of racism, you know, and so we've had this bit of understanding coming through the Canadian system, broadcast to all the people, that there is this situation of systemic racism within the structure of Canada, and so that's been acknowledged to some degree. The full realization of that is not being made, and so there's economics within that systemic racism. For me, when I try to explain it for people, I say that racism, which is a waste of time, firstly, but secondly, to describe it is a condition of subjects and vassals, which is produced by royalty. And so while the enduring, unending conflict of the position of subjects and vassals is too busy infighting to take the time to realize that royalty is getting away with murder. And so we need to address that. And so the hierarchies and the monarchies and all these other things that they're calling keys are not essential, and they don't fit within the idea of mutual agreement and coexistence, and that needs to change.
Thank you very much, guys.
Hey.